Mr. Ram, I think we were working through the Crown appeal. I think we got to G, but I'm not sure you covered everything in F that you wanted to.
Yes,
raise.
my lord, if we just have one point I would like to make under the issue F.
Yes.
Which you see under the heading, which is subheading E, which is the judge's failure in considering a letter sent to the appellant's lawyer. Page 5960. Yes.
Sorry.
I would like to.
So it's F subparagraph E.
E. And the heading, yeah, judge's failure to consider a letter.
Yes.
My lords, on this point, I submit that the appellant did have an issue, and I believe the basic facts was a letter sent by the jurors.
Well, it was anonymous, wasn't it? We don't
That's
know.
right. That's right. But it was presumed in the letter that they were the jurors. They didn't sign, but they did say that we are jurors, and that was sent to the barrister, the counsel. That letter, which was received by the judge, was received by the judge. He dismissed it on the basis that it was hearsay due to the fact that it was not signed, not given a name or particulars. On this point, my lords and lady, it was a very important letter which the judge ought to have considered, should have considered, because it has a very substantial material.
Well,
fact.
we don't know what it contained.
My lords, I know you don't, because
nor did the Court of Appeal.
my only point I'm raising here, my lords, is that if such a letter in a criminal case where life is involved of somebody
was likely to what? Sorry.
Sorry.
Where life was involved.
Where life was involved. Sorry, I just didn't hear you.
Sorry, my lords. I was saying that the issue is raised because this letter, myself had a chance to glance at it, was a very important letter.
Well,
albeit
we don't know what the content of the letter was, and we can't.
I know that, my lord. I'm just making a point that in the event a letter of this nature is received by a court, by a judge, it ought to have been considered. But in this particular case is not considered, and it is regrettable that this matter was not put forward and sent to the board as a sample to see what it was. But my point I'm making is that if
just tell me, was the letter also made available to the prosecution? When the defense barrister received it, did he make it available to the prosecution?
Yes, my lord,
right.
he did.
And they're under a duty of disclosure.
Yes.
So if there was anything of significance in it, they would have an obligation to tell the court about it.
Yes, but it was given directly to the judge as well, and the judge actually said that he would not consider it because it was anonymous, not signed, not addressed. All right? Yes. Other point he raised, besides what I said, was it was prejudicial to the case. But in the world of justice, if we want to do justice, it's very essential that any material which come to a court attention must consider it and look into it. So that's all I can say, my lords, because it is very unfortunate you don't have a copy, and I can't at this stage submit a copy. So this is a point I'm raising because it is a matter of concern for a system of justice where such a point should be addressed. Having said this, my lord, we have the other next issue about the Court of Appeals attitude. Yes. We have made extensive explanation, my lords, and it is decided that we leave it in your hand, whatever we have said, to take the views as necessary.
Yes, thank you.
Now, the other issue I have, which is I consider quite important, and I submit that the board either would think can look at my argument and accept it per se, or if any points wants to be argued further, that is J, issue J, at page 72.
You don't want to say anything about I?
Sorry?
You're passing over issue I.
I was whether the trial is a nullity. My lord, this was a very, very basic point. Yes, your lordship is right. What really happened on this, I can give you a help on the page, which is from page 1812 to 1816.
And why is it said to be a nullity? Is this to do with
Now, this is
the witnesses swearing the witnesses?
That's right, my lord. Sir, the fact in this case was this: the police officers or witnesses were giving evidence. They then left the court, came back, some after a couple of hours or some after 2 days. And what really happened, the records show that the judge did not direct the witness to say you are still under the oath or not to discuss the case when you go out and you come back, take oath again. So this, based on that generally, the court probably didn't take much care to say how serious the whole matter was. So from that point of view, appellant says the case is a nullity. And the facts to be found on this matter is the pages I gave.
Well, we have that submission. Thank you.
Yeah, I don't have much to say other than this, my lord.
So then you're going on to J.
J. Yes, Your
This
Honor.
is a very, very broad allegation, very broad ground.
Very broad, my lord. But a lot of things which have been said, not said, which is not acceptable, very prejudicial, and there are many decided cases how prosecution should behave, which was not done, and I would ask the board to consider these matters. If I can leave that either to you, the board, to look into general, or I am happy to go through and submit how prosecution acted and
Well,
why.
it may assist if I say that we've all read the prosecution opening and we've all read the closing speech of the prosecution.
My lords, in that case, I'm in your hand, my lady. I don't need to take more of your time.
Thank you.
Thank you.
And then issue K.
Yes.
This one you've touched on already, I think. We touched on it in issue D, I think, where you complained that there wasn't a joint trial and that as a result was less likely to arrive at the truth. In K, you're saying that it's a basic complaint about unfairness, I think.
Yes. Yes, well, basically the point was unfairness.
And strictly speaking, the Confederates were prosecuted for murder, but were offered the chance of pleading guilty to manslaughter. Is that right?
Well, what it was, the Confederates, yes, they pleaded guilty.
But they were prosecuted for murder, weren't they?
Whether they were prosecuted for murder?
Yeah, the initial charge against them was murder.
Yes.
Yes, that's fine. That's okay.
Yes.
Yes. And then we should hear you on ground L. We should hear you de bene esse on ground L.
Sorry, no.
We should hear you de bene esse on ground L in relation to the sentence.
Yes, my lord. Now that
To make it clear, that's not giving any indication as to you formed on or
yes, well,
may come to on other grounds. It's
I could go into that, my lord. So that's basically, as I understand it, that he was found guilty of murder, the appellant, and he was given 44 years and
42.
and was reduced on appeal. Yes, was reduced. So coming to it, and was reduced to 40.
yes. To take account of the delay,
Yes,
because it was some 9 or 10 years before this matter got to trial.
correct,
Yes.
my lord. Yes,
And during that time, he was on bail for some of it, or was in custody on other matters.
I understand he was on remand for some years.
There were some 900 odd days that counted towards the sentence.
Yes,
But he was in custody for other offences, wasn't he, in the period?
what I understand, my lord and lady, is that from 2010 he was on remand. Before that, he was. What was the sentence? In 2010, he was in remand, and for the 2-year sentence in between. In between 2010, he was on remand. And
When you
then,
say on remand, you mean on remand in custody? Yes.
yes, and 2-year sentence after that was added, and remand further. That's right. So that's what was the case.
All right.
2010 remand, he was remanded. Then there was 2-year sentence. Then after the 2-year sentence, he was again back to remand. So I presume what it means sensibly that he was sentenced for some sort of other crime,
Yes.
and he was locked up for that basis under that record, and then he came out of it, gone back due to remand for this case.
Yes. So he's been in custody since 2005.
Yes.
But
No,
No?
2005, you might put the position. Before that? Okay, my lord, so what I understand that from the time he was charged, he was on bail. And 2010, then onwards, he was on remand, etc.
And what date was he charged on? Upon what date was he charged?
The date was, you have the date he was charged, is the case of murder. Because I understand, my lord, the trial started on 11 February, so
Mr. Ramsden, I wonder if I can assist. If we look in the bundle at page 1828,
18.
this is the skeleton argument submitted by the appellant to the Court of Criminal Appeal, 1828.
Ah, yes.
Which there sets out the periods of remand in custody relevant to the present case. The trial judge calculated the relevant period as 627 days and only gave credit for 80% of those days.
Yes.
Before the Court of Criminal Appeal, it was submitted on behalf of the appellant that the appropriate number of days should be 982. The Court of Criminal Appeal accepted that submission and allowed credit in full. So the end result was that whereas the judge had given credit for 527 days, the Court of Criminal Appeal gave credit for 982 days, which in round figures is about 18 months more, counting towards his sentence.
Right. That's very helpful.
Yes.
Thank you very much.
Yes, my lord.
So although the reduction in sentence was 2 years,
Yes.
in fact, the appellant overall was about 3.5 years better off after the Court of Appeal than he had been after trial.
Yes, my lord. That's how we see it here.
Yeah, thank you.
Thank you.
So your complaint is that the allowance of 2 years for the delay in bringing the matter to trial wasn't sufficient.
That's correct, my lord.
Well, we have that submission, and we've been referred to some
Other cases.
authorities
Yes.
in relation to
Yes.
Thank you, Mr. Ramsden.
Yes, my lords, I'm just wondering whether I should take this. We have the speech of the jury's summing up, the judges summing up, but my lord, you having had a thorough look and read of the matter, I do not think it will take you further or take me any further.
Thank you.
So I would leave that out. Now the matter that we talked about under page 82, that is coming under the board's question that was raised.
Sorry, the matter we talked about under 82
yeah,
was what?
if I can go through that, which I'm sure the board has had a very good look at it.
Sorry, what is the point?
These are the questions raised by the board.
Questions raised by the board. Yes, right.
Page 82 of the...
That was page 78,
Thank you.
where your lordships wanted to understand, for example, the first question raised, issues, what, if any, was factual evidence led before the jury as to whether the appellant placed his shirt over Mr. Lazar's nose as well as mouth. So I take it the board has had a good chance of looking at it. I don't need to explain further.
We've heard you on this.
Yes, so equally the other 70, we got 4 raised by the board. I take it that you don't need me to address any further. I then have to say, my lords, that unless you want to ask me any specific questions on the facts or case of this matter, which I can answer. If there are any issues or matters or facts, factually, that I can be of assistance, I'll be happy to do so.
Thank you very much. don't think there are any questions at this stage. What we're going to do now is we're going to rise for a moment to take stock of where we are, and we'll be a few minutes. We'll adjourn for a few minutes. Mr. Ramdon, we're very grateful to you for your submissions. Mr. Director, we'd like to hear you, please, on the following issues. First of all, on the directions to the jury, in particular, any alleged misdirection in relation to intent to kill or premeditation. And we'd also like to hear you in that regard on how the judge dealt with the presumption, dealt in his summing up with the presumption that one intends the natural consequences of one's actions. Secondly, we'd like to hear you, please, in relation to the effect of the judge's reference in his summing up to the question which he had put to Dr. Gangadin and Dr. Gangadin's answer, that question proceeding on the false basis that there was evidence that the accused had covered the deceased's nose as well as his mouth with the shirt. Thirdly, in the context of premeditation, we'd like to hear you, please, on the judge's observation in the summing up that the accused had appeared to act calmly. And finally, we'd like to hear you, please, de bene esse, in relation to the appropriate reduction in sentence to take account of the delay which occurred.
Yes, I begin my vote. With regard to the first point, the alleged misdirection regarding the intention to kill, the judge addressed the jury in his summing up on intention to kill at page 281.
Are we working from the record?
Yes, the record, page 281 to 283.
Yes.
Your Lordship will see that the learned judge explained to the jury about the requirement with regard to intention to kill, and he refers that you can, on the facts of the case, that is, you can infer intention, or you can rely on evidence of intention, either if there's a confession, or you can do that if you have sufficient materials before you in order to make the appropriate inference. That is, he explained the different ways you can ascertain the intention of a defendant. That is at page 281, line 21. Intention refers to mental state. So how do we work out this mental element concerning the accused? And after he referred to the confession, he referred also to the possibility to make inferences in order to decide, look at surrounding circumstances with a view to decide whether he had intention to kill or not. And it is important to, in my humble submission, it is important to understand the context in which he directs the jury at page 282 of the record at the top, when he referred to assumption, what he said, and I will quote that part. Finally, because it is so easy for somebody to do something and then to say subsequently that he did not intend to do it, the law stipulates that we can act on reasonable assumption, namely that a person must be deemed, he must be taken to intend the natural consequences of his act. And this part, my lady and my lord, what he was telling the jury, it should not be confused with somebody who, without having the required intent to kill, but is still must have foreseen the consequences of his act. What the judge, the learned judge, was saying is that if, for example, you have somebody who points a gun at a victim and shoot him in the heart, subsequently he said it was not his intention to kill him, then this contention can be rejected, because when one points a gun at a victim, on that part of his body, the intention is very clear. He intended to kill the victim, otherwise he wouldn't have used a gun and fired him hard. It is in this context that he referred to the French extract, which we have referred to this morning. And I would wish to refer your lordship to an appropriate extract in document.
So just before you go to the extract,
yes, my lady.
In two places in that passage, the judge appears to be saying that there is a legal presumption or legal assumption.
Yes.
And you told us earlier that there is no legal presumption in Mauritian law. So that those were misdirections, weren't they?
Legal presumption, generally speaking, there are legal presumptions in Mauritius, but in this particular context...
in relation to this?
No, my humble submission, my answer to your lady's question is that he was referring, in fact, to the circumstantial evidence which one can take, the facts, the evidence, the circumstances, in order to make the necessary inferences.
But he says the law stipulates we can act on a reasonable assumption that a person is deemed, he must be taken to intend the natural consequences of his act. And he says that again, the law will assume he intended the natural consequences of his act.
He says we can act.
Sorry?
We can act on a reasonable assumption.
And then later the law will assume that he intended.
Yes.
He was referring to inferences, made inferences which the jury could make from the facts of the case.
Well, why does he say the law will assume?
The law, he was referring to a French text, which is, as I pointed out this morning, regarding the French doctrine regarding the possibility to actually make inferences from facts which have been put before the jury.
But Mr. Director, help me with this if you could. The French quotation, which begins at line 11 of this page, as I understand it, it simply indicates that the actor is responsible not only for the consequences he foresaw and wished, but also for all the consequences which follow. That I think, is a rather different point. But going back up the page to the passage my lady was asking you about, I wonder whether the problem with that example is that, having said at the top of the page that we can act on a reasonable assumption, the example given might be thought to look much more like an irrebuttable presumption, because the judge states the law will assume that he intended the natural consequences and therefore intended. So one asks, for example, the rhetorical question, well, what if the accused's answer was, I didn't think the gun was loaded? On the face of it, the judge's example would seem to indicate that the law will in any event presume that if you actually point a gun at somebody and actually discharge the bullet, then you must be taken to intend the consequences.
I mean, the example given by your lordship, there would be kind of evidence elicited to rebut that type of presumption. That is, if, for example, there's evidence that the gun was not loaded, then surely the jury would be made aware about that, and they would not be able to make that inference that he intended to do it. So that is a general statement of the law that the learned judge was referring, and more specifically, as I pointed out earlier, he was giving a specific example regarding the pointing of the gun at a part of the body which is more likely to cause death, and therefore that would allow the jury, for the example that he has given, to make an inference which could be very strong, a strong inference. That's the point that the learned judge was making. But it's not, if I may explain it that way, it's not like an irrebuttable presumption which in no circumstances would the other party, for example, bring evidence and show the contrary. I do agree with your lordship that this quotation, this extract that the learned judge quote here could give rise to some kind of confusion. But if you look at the doctrine, the French doctrine, we say that all that this part says, this extract says, is that there is a strong inference to be made with regard to intention when it comes to pointing a gun at a vulnerable part of the body. Nothing more and nothing less.
It would have made our life much simpler if he said there is an inference of fact which you can draw from.
I do agree with your lordship. Yeah. I mean, it could have been made simpler. Yeah.
And tell me, is there an onus then on an accused to rebut a presumption? But if you raise circumstances which give rise to an inference, is there an onus on the accused person to call evidence to rebut that? And so that is, it's not on the prosecution to prove their case beyond all reasonable doubt. It's an onus on the accused then to rebut a likely inference to be drawn.
Not really. There's no onus on the defendant, but there is an element of risk. Yes. If the prosecution has adduced sufficient evidence which might make one say that this is beyond reasonable doubt, it would be very risky, for example, if the defendant doesn't adduce any evidence. But that is not to say that the onus is on the defendant. And there is the important principle, we all know about the right to silence of a defendant. His right not to say anything, because it is for the prosecution to prove the case against a defendant. But sometimes a defendant would be expected to do some kind of evidence in the light of the evidence elicited by the prosecution during their case. a failure to adduce evidence may give rise to adverse inferences which the jury could make. So without disputing the right to silence, the right not to give evidence, the burden is on the prosecution all throughout. Still, there would be some kind of onus, if he so wishes, to adduce some evidence. And there was a case of the Supreme Court where the learned judge on appeal clearly made that statement. And if I'm not mistaken, in the UK, that rule has been made statutory.
Yes, yes.
Yeah.
It was introduced on a statutory basis, I think might be the more accurate way of saying it.
So that is...
but you'd certainly have to direct a jury about the circumstances in which they could rely upon such a failure to adduce evidence. And there aren't any such directions in this case.
In this case, the judge did direct them on the burden of proof, but the burden of proof is on the prosecution all throughout. And the defendant doesn't need to do anything. That is... That is to be found somewhere in the summing up, where the learned judge directed the jury on this issue. That is at the beginning of his summing up. And may I also say, my lady and my lord, that presumption is a kind of translation of présomption in the French text. So when we speak about presumption, the equivalent of the English text presumption is présomption. So the summing starts at page 256.
Burden of proof is on page 263.
The record 256 to 257. Both the prosecution and the learned judge did direct the jury about where the onus lies in a criminal case. And they made that very clear. I can read at page 262 of the record. Line 15. I therefore propose to deal with the matter in the 5 headings when he was dealing about the procedure, the rules. First, he addressed burden of proof. This will take us into the issue of who has to prove what in this case. And then he mentioned the standard of proof. And this is developed at page 263 of his summing up, 263 of the record. He refers to section 10(2)(a) of the Constitution of Mauritius. Every person who is charged with a criminal offense shall be presumed to be innocent until his proof or has pleaded guilty. He mentioned the fundamental principle of criminal law in Mauritius and many other countries. An accused who is sitting there is deemed to be innocent until he has been found guilty to the satisfaction of the jury. There's no burden whatsoever on the accused to prove anything in order to establish his innocence. An accused can sit back in the dock and say absolutely nothing, and no adverse inferences, I will stress this, no adverse inferences are to be drawn from that, and in particular his silence is not to be considered as an admission of guilt. And he went on to explain the consequences of these important rules in the criminal trial, and the prosecution did the same thing in their closing speech. Therefore, In my humble submission, he addressed this issue sufficiently as to who need to prove what, and the onus lies on whom. The learned judge when he addressed the jury at page 282 of the record, he summarized for the jury the evidence which been elicited. And one interesting feature here at page 282, line 25, when he mentioned the evidence, said the victim had been beaten up severely. He already had a piece of paper in his mouth. His mouth had been tied by circling adhesive tape on his mouth, around his face, and the back. He didn't mention nose at all at this point in time. Again at page 283, line 5, when he referred to the evidence, the 6th point, Roman numeral, he said, yet the accused took his shirt, rolled it around the mouth, face, and neck of the victim and tied up the long sleeve quite tightly at the back of his neck. Again, no mention is made about the nose. And the judge, in my submission, was very careful in his summing up when further down, line 10, he said, I want to make one thing clear. I'm not giving you, and I will not give you the answer to those questions. It will be for you to decide in your deliberation, discuss, and find the answers for yourself. And on this issue about intention, he referred to evidence which he said were relevant for the consideration of the jury in order to decide whether there was intention to kill or not. And what are these questions that the learned judge put before the jury was, first of all, he said, what was the need to tie his mouth again with the shirt? And in fact, this is a very important and relevant question which the jury must have addressed. I mean, the victim was almost dead. He was powerless. He couldn't move. He could hardly move. And what was the point to tie a shirt on his mouth? He was already gagged with papers in his mouth and sellotape. He was face down on his belly. He was injured seriously. And despite all this, the appellant decided to tie his shirt on his mouth. So that was an important consideration, which in my submission, the judge was entitled, and rightly so, referred to the jury for them to decide and to ask whether they could infer intention to kill in these circumstances. And also he referred what state he was, the number of cone bags which were placed on his body, and then he left it at page 284 to say, did he intend to kill the victim or not? The intention to kill, which I've just explained, it is for you to decide on this issue. So, in my humble submission, the learned judge rightly directed the jury with regard to the element of intention to kill. It was all circumstantial evidence. There was no direct evidence. As my Lady Simler said this morning, all that we had was the statement. So that was the evidence. And it is from there that they had to decide whether they could make the necessary inferences in order to find intention to kill, prove or not, beyond reasonable doubt. And they did find that there was intention to kill. Can we say in these circumstances that the verdict of the jury on this specific point was perverse? I submit with due respect, no. Then the learned judge referred to the element of premeditation. So the first part of my submission, that is, I've addressed the alleged misdirection, that is, intention to kill presumption. Now, also, I think my Lord Stephens rightly pointed out this morning, I think, again, we need to look at the context in which this incident happened. And then there is the issue about who did what. There's the issue of premeditation. There's the issue of intention. When we look at the locus where the incident happened, there was no division at all. There was the control room, there was the office where the victim was seated, and there was the compartment, the vault, where he collected the money. So and we look at the plan this morning, a question which the jury had to decide was, I mean, when this was happening, when the victim was assaulted, was it not within the sight of the appellant? Didn't he know what was happening? And therefore, what was the point to tie his mouth with a shirt? Also, we know when we look at the statement, the Vinessen, the guy who called Vinessen gave them instructions not to cause any injury when committing the robbery. But the appellant, when he recruited one of his friends to do the robbery, he said, we will need to attack. We will need to go there and attack people. So it was assumed, they decided beforehand that they would use some kind of violence on the person who would be found there. And also, we know in this case, when we look at all the circumstances, they didn't wear any mask. They didn't wear any gloves. Despite the fact that Vinessen gave them instructions, gave them money to buy materials in order to make gloves and masks, but they did go there without any mask, which means that their identity was known. And therefore, if their identity was known, I submit a reasonable jury could infer that the intention was not simply to muzzle the victim, but it was much more than that. There was nothing to muzzle. The state where he was, he could not move, he could not, the doctors say, breathe, he could not shout and ask for help. So what was the point? And that was an important consideration that the jury had to decide, and which they did. And also, my lady and my lord, as far as the issue of that is what I was asked to address, that is any alleged misdirection regarding intention to kill, and the presumption which I've addressed, natural consequences. Now, I would wish to move on with regard to the summing up with regard to the mistake of the nose. Now, we do concede in our written case that the learned judge did make a mistake regarding the mention of the nose being tied. And I would wish to, in fact, draw the attention. I've already, your lordship, your lady and your ladyship, the context in which this happened. There are many instances in this case where, in fact, reference is made to the mouth only. And we address this in our written case under the heading Issues Relating to the Mistake Regarding the Nose. At paragraph 34, we say that, regrettably, the judge did not redirect the jury on the mistake he made. However, this omission he submitted was not so serious. Why do we say it was not so serious to constitute a miscarriage of justice? Because we say that the judge referred to mouth only in many of the instances. I referred this board already, page 280, line 8, page 281, line 13, page 283, page 282, page 287 of the record, 2 times. My humble submission.
But in those later, I'm so sorry to interrupt, in those later ones, having at 280 referred to the nose, in the references on 281 and 282, or 282 and 283, he talks about mouth and face.
He refers to mouth and face, yes. But
who knows what the jury made of that, having heard the judge say mouth and nose?
yes, that is, again, I think we need to consider the evidence on its whole, because we have the officers, the witnesses who gave evidence. There was the officer Salabi, Mr. Salabi, there was Officer Nochetram. They said very clearly that when they went on the scene, the shirt was on the mouth. The jury was aware about this. The jury was aware, and therefore, the case for the prosecution also was that the shirt was tied on the mouth, not on the nose. And even the judge, in many instances, mentioned only on the mouth, not the nose. So the question is, could the jury have been misled in believing that the shirt was tied on the nose?
What's the test under Mauritian law? I think you accept there is a misdirection here. You say it's not significant because there are other directions given. But if it is a misdirection, and it isn't balanced out in some way later on, what is the test under Mauritian law as to whether an appeal should or should not be allowed?
Yes.
And is there a proviso
Yes.
that can be exercised?
There is a proviso. May I refer your lordship to the Court of Criminal Appeal Act. We have this at page 587. More precisely, my lady and my lord, at page 589, section 6, clause 6, determination of appeal in ordinary cases.
589.
Yeah, the e-bundle, page 589.
And would a misdirection be a miscarriage of justice?
Yes. I refer to section 6, subsection 1a. The court on any appeal against conviction shall allow the appeal if it thinks that the verdict of the jury should be set aside on the ground it is unreasonable or cannot be supported, having regard to the evidence, or that the judgment of the court before whom the appellant was convicted should be set aside on the ground of wrong decision of any question of law, or that on any ground, any ground is very broad, there was a miscarriage of justice, and in any other case shall dismiss the appeal. But B, small b, says, the court may, notwithstanding that it thinks that the point raised in the appeal might be decided in favor of the appellant, dismiss the appeal if it considers that no substantial miscarriage of justice has actually occurred. And we say that in this case, for the reasons I've given, there could not have been a substantial miscarriage of justice on the issue of the mistake of the judge regarding the nose. In a way.
But before you get to B, to come within A, you've got to show a misdirection that the court is satisfied has caused a miscarriage of justice, not just a misdirection.
Misdirection, yeah, on fact. Yeah. I mean, not all misdirection may amount to a miscarriage of justice.
Yeah.
If that misdirection of fact does amount to miscarriage of justice, then
Even if you reach that conclusion, there's a proviso. If there's no substantial miscarriage of justice, you can still dismiss the appeal.
Yes, you can. You can. And this is what we say. Either it's not a misdirection at all. It is an error in itself without more. If it is a misdirection, then the proviso can be applied. And I refer your lordship to a series of cases, some decided by this board itself, where the proviso has been applied.
The usual test is that you have to be certain that the person would have been convicted.
Yeah.
So,
If not that mistake, the jury would still have convicted the defendant. And we say there was sufficient evidence on record, even without the mistake of the nose, because if you look at the evidence of the doctor gave evidence and explained how the tying of the shirt contributed to the death. How it
the
accelerated
contribution to the death is a slightly different issue from intention. And I asked earlier on that if you occlude both the nose and the mouth in a person by tying something tightly around both of those, isn't that powerful evidence of an intention to kill?
Let us assume, I think my Lord Stephen asked a very relevant question, very good question. That is, let us assume that there was no mistake regarding the nose, and if the judge was aware that only the mouth was tied, would they not have, in the circumstances, also render a verdict of guilty?
Well, they certainly could get to a verdict of guilty. Sorry, they could certainly form a view about intention a great deal quicker if they had, if both the nose and the mouth were blocked.
I do get the point. I agree with your lordship.
And so the evidence of intention would be stronger on the basis of the misdirection, if it is a misdirection, as opposed to
if it is a misdirection. Yeah. But yes, a question of whether a conclusion could be drawn more quicker than if it was not on the nose. I do get the point, but my submission is that even if the jury was not told about the mistake regarding the nose, and that the shirt was tied on the mouth, there was a reasonable jury could have come to the conclusion.
Well, it could have, isn't the proviso
infer that intention.
The proviso test is would have rather than could have, as far as I understand it. Now, correct me if I'm wrong.
No, my lord is right. Yeah.
And how could a jury not conclude that there was an intention to kill if somebody deliberately ties tightly a shirt around both the mouth and the nose. I mean, what avenue of escape is there for the accused there? There isn't.
I don't see any other explanation.
Yeah.
Because as I said earlier, there was practically no need to do that. In the circumstances, the defendant could have dissociated himself. He could have said, no, there's no point, I'm not going to do that.
Yeah.
He joined in, and this is where we say, in fact, he acted as a co-author. And when we look at co-authorship, he's being charged as a co-author, a joint enterprise, so his participation becomes even minimal. What is required is even a less degree of participation on his part. And this issue brings us to the actus reus and as well as the issue of causation. We say in this case there was sufficient evidence on the evidence of the doctor which was not challenged. When the doctor gave evidence, testified about the contribution of the tying of the shirt on the mouth, at no point in time he was cross-examined. Before this board, we heard this morning that this could not have caused the death, but we don't have that evidence. But the victim was still alive. The doctor was not cross-examined on this at all. So how, for the first time before this board, can we submit reasonably to say that a shirt could not contribute at all to the death, or that the victim was still alive? There was simply no challenge to that evidence, remained undisputed. I think the case for the appellant before the lower court was only that he would have passed anyway. But this was not our case. Yes, he would have died anyway with the tying, with the inserting of the papers in his mouth, but we say he also acted as a co-author. So on that basis, therefore, we say that the mistake regarding the nose was not so serious. In fact, if we were to look at the evidence, that is, what was the context in which that evidence was introduced, we will see that it was one instance, and in a way, the learned judge not remedied the situation directly by telling the jury, I made a mistake, but the fact that he mentioned nose, and nose subsequently, as well as the prosecution, I don't think that I can.
He mentioned mouth.
He mentioned mouth. Yes. Yeah. It was. I think it was a slip of the tongue on his part, because otherwise he would not have mentioned immediately after mouth.
Well, he says mouth and face.
Yes, my lady. And then the focus about the cause of death was about the air passage. Everything was focused on this. That is the cause of death, about the inserting of the papers into the pharynx, and the broken nose, which aggravated the situation with the swelling, with the blood going down, and therefore which made the almost impossible for the victim, for Mr. Lages, to breathe correctly. That's why the doctor said within 3 to 4 minutes maximum he would die. And on that issue, I'm sure my lady and my lords have had the opportunity to look at the photographs which we have put in the bundle. What state Mr. Lages was, the blood was on the floor, his nose was broken. Now, in addition to that, you put the paper, you put the sellotape, and you put on top of that the shirt. You are simply committing a murder. You're killing that person. There would be no chance of survival in these circumstances.
There was no chance of survival without it. The doctor said he would have died anyway.
He would have died anyway, but by doing that, you are simply ensuring, you're making sure that that Mr. Lages would simply would die. Otherwise, what would have been the purpose of doing that? I mean, this is something which the juries, the members of the jury, must have considered, and they decided that it satisfied all the limits as directed by the judge. So,
could you help me? Sorry for interrupting, but before the judge gives his charge to the jury, there is an exchange with counsel in which the issue is raised that the witness never said no's. I wonder how that played out. It's at page 206, and I haven't been able to trace it all the way through.
yes.
Well, it starts at page 205.
Page 200.
The doctor has never said that the shirt was on the mouth, not the nose. So that's referring to Dr. Gungadin.
206?
205.
205.
Line about 12.
I'm sorry, my lord. 204 line.
205, line 12.
12. Yeah.
He said the shirt was on the mouth, not the nose.
Yes.
This is what he said.
Yes, yes.
And I presume the doctor is Dr. Gungadin, is that right?
Yes.
And,
thank you, my lord.
And and I think he's accurate insofar as, well, the judge introduced the concept of the nose.
Yes.
And the witness only said the mouth.
Yes.
And
yes.
so the judge is in effect being warned that there is a problem with that question and that answer that he made. And I was just wondering, there was a suggestion that they would check the court record. And I was just wondering how that played out, whether they did check the court record and find out prior to the charge that it was all along just the mouth.
Yes.
I'm sorry for asking that.
No, I mean the counsel said he said that the shirt was on the mouth, not on the nose. That is what he said in chief. He said it was on the nose. He said in chief, no mouth. In chief, he was specifically asked, and he specifically said nose. And then on this point, this is hearsay because he was not there. This is hearsay. You didn't challenge the evidence. But prior to that, at the top, the court said, which is precisely the point we are trying to make this in this case, showing that this person is going to die. And we have the result: the person could still breathe through the nose with difficulty, but with the shirt on his nose, that impeded. At the end of the day, the presence of the shirt did play a role in causing the death. So the point is, do we have a causal link or not? That part was at the stage of...
They said they were going to look at the transcript and then we go straight on to the closing speeches. Do we not?
Well, I think it's before the submission of no case.
Yes, the submission of no case.
Yeah.
So that was made in the absence of the jury.
Yeah.
And at 208, it's left on the basis they'll come back to it when they've got the transcript tomorrow morning.
Yeah.
We don't think we've got a record of what then happened.
Yeah.
Yeah. So certainly that was the jury wasn't aware.
I mean, do we have the ruling of no case anywhere? Where do we have
do
that?
have the ruling. Yeah. It's not part of the record, but we
it
do
might be
have
helpful to see it because the judge would have gone through the evidence.
Yeah, we can provide the board with that ruling if need be. Yes.
That'd be helpful.
Yeah. So, unless I can enlighten the board on this particular issue, anything that you would wish me to address on the issue of intention before I move on to premeditation?
Mr. Director, can I just take you right back, please, to the statutory provisions which you were helping us with? The Criminal Appeal Act. Looking at page 589, foot of page 589 of the bundle, the provisions as to determination of appeals. 1A is circumstances in which the appeal shall be allowed. 1B is the proviso, no substantial miscarriage of justice. Can you help us, please, with little c? Is there any case law on what does or doesn't amount to a serious irregularity?
There is, my lord, there is the case of this board itself, the case of just gave you the reference. Yes, it is here in front of me. The case of DPP and Largesse, which is reported in 2020, UKPC 16.
Is it in our bundles?
Sorry?
Is it in our bundles?
Yes, it is in our bundle.
Lesage
That
and
is,
MCV 2012 UKPC 41. It's in the bundle of page 287.
Or is that a different case?
It's a different Lesage, is it?
no, c'est pas ça. No, I apologize, my lady. It is not in our bundle, unfortunately.
Well, we can get it on the internet here. It's
Yes.
okay.
Yes.
So the name of the case again, please, and the reference.
The name of the case is DPP and Largesse against
And how do you spell that?
L-A-G-E double S-E.
L-A-G.
E double S-E.
Victim in this case.
Like the name of the victim in the
Oh,
original
yes,
case.
yes.
And that's what is in the bundle. And in this judgment, the board refers to another case, a Mauritian case decided by the board, the case of Dasurat, which is in our bundle. 372. So, yeah. The Surat and the state decided in 2004 UKPC 51.
Yeah.
And so the Largesse case, what is paragraph 34, is it? Or?
Yes. 26, that is, and 27, reference is made to the case of Dussurat.
Sorry, you're referring to paragraph 26 of...
26 of the case of Largesse.
Well, 25 of Dussurat says the constitutional guarantee of a fair hearing in section 10.1 requires that a generous construction should be given to the expression serious irregularity.
it's a very broad power given to the appellate court to decide when the court reached the conclusion that there's a serious irregularity, and to order the trial to be a nullity and then order a fresh trial.
I'm sorry, this is paragraph 25 of Dosseruth.
In fact, there the legislation was defective, so it's pretty obvious irregularity.
Right. Now, on the
a quick read through Largesse, it's a broad interpretation is given to a wide construction is given to serious irregularity.
yes, yes.
And it gives rise to a discretion as to whether to declare the trial a nullity and to order a retrial. And so one has to think about a wide construction of a serious irregularity.
Has that been relied on in this case, apart from a nullity point?
No?
No, it hasn't been. I don't think so.
Yes, I think it's a question of the nature of the present misdirection need to be considered and then decide whether it would amount to a serious. But to the extent that we submit if it would have been a case where the reference was made only to the mouth, nose, mouth, nose, mouth, and nose, that would have been a different matter. But here we submit that there are so many instances that the jury could not have labored under the wrong impression. The focus was the tying of the shirt on the mouth. The case, in fact, was focused on the evidence of the doctor, on the evidence of the police officers who saw the victim for the first time. And if we look at the evidence of the cause of death, which had nothing to do with the nose, except that the nose was broken, but everything was focused regarding the papers and the shirt, the gagging. That's that the cause of death in this case is asphyxia by gagging. So to that extent, the nose plays a less important role overall when we look at the whole evidence.
So, in short, you accept there was a misdirection, you say it's been counterbalanced by proper directions that have been given, and then overall it's not a misdirection.
This is my
and if it isn't counterbalanced, then what?
The verdict of the jury is valid. I mean,
Sorry, is?
the verdict of the jury can be considered to be the correct verdict that they reach when looking at all the evidence. May I move on to the issue very briefly, my lord, on the issue of courtship, because the appellant this morning has referred to the issue of causation, to what extent the tying of the shirt has caused the death, in addition to the evidence of the doctor, which was not challenged, but also we must not lose sight of the fact that the appellant was charged as a courter, and therefore his act, his contribution, even though his degree of participation, even though is very minimal, that would still satisfy the requirement to find him guilty for the offense of murder. And I rely on the cases, on the following cases, of some French Mauritian cases.
This is the concept of joint enterprise, is that
It's
right?
the concept of joint enterprise, my lord.
So there's a joint enterprise to commit murder, or what?
Yes, the joint enterprise, the intention, the limit required for intention must be to commit murder.
Right. And so all three co-conspirators have that intention?
Yes.
To,
Yes.
and, right. And that joint intention was formed when?
It was formed. I mean, the prosecution presented two scenarios. One was it happened well before, even before they went into the bank. That was one scenario which was presented to the jury, and the other one was that if we were to rely only on his statement given, his written statement given to the police, then everything happened inside the bank.
Okay, so to have a joint enterprise, there's got to be a mental element of the co-conspirators, and they have to, that mental element, either express or tacit, has to be an intention to kill.
Yes.
Where does the judge direct the jury about that mental element of
Yes.
authorship of
joint enterprise?
Of joint enterprise.
That is to be found, my lord, my lady, at page 278 to 79 of the report. So page 278, page 9, line 19. So the learned judge explained to the jury that murder can be committed by one individual, so one person. It can be committed by several persons as well. And he told the jury that care has to be exercised. Number one, there are cases where it is clear that one assailant dealt the fatal blow to the exclusion, and I'm being very clear, he said, one of the assailants dealt the fatal blow to the exclusion of all others, in which case he is to bear the responsibility of the blow. And the important part is, he said, however, when all assailants commit a series of acts which are interconnected, which form an integral part of the events that lead to the death of the victim, they are to be dealt with jointly.
And where's the mental element in that?
Then he referred to the version of the accused further down. He referred to the version of the accused, what he said about the piece of paper, and here the focus was on the tying of the shirt. That is the second scenario. Then he said it is for the members, for the jurors to decide which one. And then he mentioned the causation issue.
Does he deal with intention in relation to joint enterprise?
Yeah, I don't think he deals specifically. I don't think he deals specifically with intention and causation. Although at page 278 he mentioned what I read just now, line 28. This is so because the assailant acting together, or as we say in French, agissant de concert, and the furtherance of a common purpose, commit the act of killing together. So he was explaining.
Common intent.
So do you agree that he doesn't deal with intention for joint?
Not directly. Not directly.
Was that a misdirection?
It was not a misdirection in the sense that he directed the jury on intention generally, sufficiently, and therefore a failure to address the jury on that specific point, causation and intention, would not be fatal, in my humble view.
It's even more complicated, isn't it? I suppose, I don't know, in Mauritius, because the mental element must include joint intention and joint premeditation, presumably.
Yes.
And so he, as my lady has observed, he hasn't directed the jury about joint intention in joint enterprise, and he hasn't directed in relation to joint premeditation.
Joint, yes.
Yeah.
And does it matter that the other two pleaded guilty to manslaughter and so not to premeditation? Does that have any impact?
On the verdict
The
of
joint intention
Yes.
to kill and to commit a premeditated murder?
an impact, my lady, mean an impact on the verdict of the jury?
No, an impact on what the judge would need to say to the jury about joint enterprise and what they would need to be sure of.
I would say no, because the judge was focusing on the statement of the accused. That's the evidence that was put before the jury. What happened to the other co-authors was not before the jury. They were not aware about it. But the jury, from the extract I have read, not the jury, the judge, mentioned about more than one assailant. So she was referring to more than one person. And the jury could only have understood, because the statement of the appellant was before them, that he was referring to the three of them, only three of them. So they must have had in mind that there was, that is, the joint enterprise was among these three people, without mentioning directly to them about the two other ones, they pleaded guilty to manslaughter and so forth, but that was the evidence which was before them. And he could, in fact, refer to joint enterprise because precisely there was this statement, written statement given, which was put before the jury, where the appellant explained the role of each and every one.
Well, there certainly was a joint enterprise to commit an assault, and there was a mental element there, that they were all prepared to commit an assault. The difficulty at the moment that I see is establishing a joint enterprise with the co-conspirators. The judge saying, well, you've got to be sure that the co-conspirators also had an intention to kill and also had an intention, a premeditated intention. And at the present, I can't see that in the directions he gave.
He didn't say so. Again, he didn't say so directly as as my lord has put it. I agree.
Yes.
But the idea was conveyed by referring to the statement, by referring to the assailants, and by referring to circumstantial evidence. In fact, to infer joint enterprise with intention, premeditation, could only be by circumstantial evidence.
And of course, the appellant or the accused could have, but chose not to, introduce the fact that his co-conspirators were guilty of manslaughter. He could have said, well, the prosecution accepted. That would be evidence, presumably, of a lack of premeditation on the part of the co-conspirators.
But the co-accused were charged initially with murder.
I know.
Charged with murder.
But that wasn't pursued.
It was not parachute because they decided to plead guilty to manslaughter. But that is a different issue.
You
Plea
can't
bargaining.
present a case. You can't present a case as if they were guilty of murder. If there was acceptance that they had pleaded guilt, an acceptance of guilty pleas to manslaughter.
I understand the point my lady is making. I would say yes, but is to the extent that you were relying on that evidence. Prosecution was not relying on that evidence about the co-accused. The two other parties pleaded guilty on manslaughter. That was not before the court. That was not before.
I understand, but you couldn't convey the impression, could you, properly? Perhaps you can, that they all had an intention to commit a premeditated murder in those circumstances. Could
My
you?
answer is yes. This is what the jury were invited to do. That is, in these circumstances, the jury could infer that all three of them wanted to.
But even though the prosecution had accepted guilty pleas to manslaughter.
To what extent, when it comes to guilty pleas, it's all about plea bargaining. So, strictly speaking, it's a question of discretion using for reason X, Y, and Z to accept a lesser charge to avoid a public trial and so on and so forth. But when it comes to evidence, evidence remains the same, really. The evidence that the way that the appellant described what happened inside the bank or prior to the robbery remained the same, independently from the guilty plea or the reduction in the charge. In fact, we referred to the case of, in our printed case, paragraph 79 in R and Y Daly.
So, paragraph?
Paragraph 79, my lord.
Thank you.
Yes. Where it was, I quote, it was said by the Supreme Court, convenient to reiterate the well-known principle that where several offenders are jointly charged as co-authors, the part played by each of them in the commission of the offence must be examined separately, and that the acquittal, non-prosecution of one or more, is no bar to the conviction of the others, provided, and that is the important part, all the elements of the offence are established against them.
Well, that's the point, isn't it? All elements of the offence must be established against them.
Yes. So we say that on the basis of the statement, what the evidence that was put before the jury, there was sufficient evidence to establish all the elements of the offence. I also rely on the case of, in our supplemental bundle, the Hong Kong case.
That's Hui Chi Ming,
Yes.
which starts at about page 20 or thereabouts of the supplementary bundle.
21.
Yes.
Where I think in that case, if I remember, the co-accused had actually been acquitted by a jury of murder and convicted of manslaughter.
Yeah.
If I remember correctly?
Yes, in that case, in fact, one of the issues was about the exclusion from evidence of the fact that the alleged principal offender had at an earlier trial been acquitted of murder and convicted of manslaughter. And
that was held not to be a bar to maintaining the allegation against him.
And the point that was taken in this case, and to reply to the point raised by my learned friend about the prosecution decision to accept a guilty plea, a reduced charge, one of the points in the case of this case was that the alleged abuse of process constituted by the prosecution of the appellant for murder, after the alleged principal offender had merely been convicted of manslaughter. That is, that was one of the complaints made in that case, and as your lordship rightly said, that is, the first one was manslaughter, the charge was manslaughter, the second one was murder, and the prosecution in this case as well, they were ready to accept manslaughter, a guilty plea on manslaughter. And the board said that the Crown Counsel offered to accept a plea of guilty to manslaughter from the appellant, but the offer was refused, just like in the present case. The offer was refused. And what the board said was that the evidence of relating to the other co-accused was strictly irrelevant in the case where the appellant was prosecuted. I quote at page SB 23, first paragraph, the appellant's counsel, in order that the jury might know of the result of the earlier trial, wished to adduce evidence of Apo's acquittal of murder and conviction only of manslaughter. The prosecution, however, objected to this course, and the trial judge upheld objection. The Lordship have no doubt that he was right to do so because the verdict reached by a different jury in the earlier trial was irrelevant and amounted to no more than evidence of the opinion of that jury. On the point about the decision of the prosecution to accept a lesser charge, it was said at page 30, if there was any complaint, first the point should have been raised before the trial court as an abuse of process. Because it was the contention of the appellant in this case that to prosecute the appellant for murder rather than manslaughter amounted to an abuse of process, which would have justified and even called for the trial judge's refusal to allow the prosecution to proceed. It is unfortunate in a matter involving the exercise of discretion, no application based on this ground be made either in the court of trial or in the court of appeal. So this point is being raised for the first time. That is the decision of the prosecution not to proceed. And it was said in this case, unless the decision not to go for the more serious offense amount to an abuse of process or was oppressive, there was nothing wrong for the prosecution to proceed in that way. And the test at SB 33, it was laid down. After having reviewed the facts, the Lordship found no aspect of this case which can credibly be described as an abuse of process, something is unfair and wrong, but the court should not allow the prosecutor to proceed with what is, in all respect, a regular proceeding.
So that part of the decision survived Jogi?
Except with regard to Jogi, I think in the case of Jogi, mention is made of that case, and they didn't agree with, as far as joint enterprise is concerned, foreseeability tests.
Yeah.
Yes.
Yeah.
Except with regard to that part, the judgment is valid.
Yeah.
Mr. Director, can you help me with a somewhat different point? I'm just looking at the facts of this case and the evidence of Dr. Gungadin on causation, which, as you say, was unchallenged. It might be said that a possible basis for presenting the case against the appellant was that regardless of the intent of the other two, if he acted with the necessary intent and premeditation in covering the mouth as he says he did, then in the light of the doctor's evidence, he would on his own account have done an act which accelerated the death and thereby materially contributed to it. So that would be an approach which could, in theory at any rate, enable a court to be satisfied of his guilt, whatever was in the mind of the other two. But am I correct in thinking the case was never put on that basis? It was always put on the basis that there were three of them acting jointly.
No, the prosecution, I think, presented the jury with two scenarios. One was that it was only on that basis that your Lordship just mentioned, that is, the case story of the prosecution was that also that they acted jointly only when they were within the bank.
Yes, but still a joint act at that stage. The possible approach I'm inviting you to confirm never was put before the jury was to say that even at that stage, regardless of what the other two had in mind, if he had the necessary intent and premeditation, his actions would render him guilty of murder. I don't understand the case was ever put on that specific basis.
The case of the prosecution was that was focused only on the act of tying the shirt by the appellant. That is, the focus was what he admitted in his statement. That is, he tied the shirt on the mouth. Yes, that is the prosecution, when making submission to the jury or adduce evidence, was focused only on the part played by the appellant. But they could not be dissociated completely, because the evidence of the doctor was that there was a gagging by the two other parties, and then he came and he tied the shirt. So in that sense, it was a joint enterprise. They all had the same objective purpose, was to kill the victim. There could not have been any reason to tie his mouth to that extent if their concern was only to prevent the victim from asking for help. In that sense, we say it was a joint enterprise.
Yes, I understand that. Thank you.
Thank you. Yes. Also, maybe I should add on that, that is, the judge presented to the jury the evidence adduced by the prosecution with two different scenarios. One when he acted on his own, and one when he acted together with the others. May I submit on the, if need be, on the degree of participation which is required when more than one person is acting together in a joint enterprise. I referred to the cases in our bundle. A first case I would wish to refer to is the case of Rochaya, which is in the bundle of authorities at page 633. This case explains what is the degree of participation which is normally required for someone to be found guilty of being a courtier, as well as the doctrine of courtship and intention. And this is what is known under French law as providing l'assistance réciproque et simultanée d'action, that is, where two persons or more act together, and it is the act of cooperation which is important, and when they decided to act together, that is, the intention in this case. Several examples were given, like when two or more persons acting together to commit murder, the intention must be to kill. When two persons act together to commit larceny against, the intention must be to obstruct the property. In this case, it was when two or more persons acted together, one decided to commit the rape, the other one hold the victim, immobilize the victim. There was no intention, the Supreme Court said, was no intention to commit the rape, but he was only acting as an accomplice. So in this case, at page 634, the Supreme Court said that on the facts of the case, in the first case, several others engaged, all intending to profit by the larceny. Acts of cooperation were simultaneously performed. They were mutually assisting each other, and therefore satisfy the requirement of acting together, simultané d'action. And this case, also we have the case, important case of Alexis. Alexis is in the supplementary bundle.
But the test is that it's not only the acts of cooperation
Yes.
were mutually assisting each other, but they both mutually assisted each other in the commission of a rape. I mean, they had the mental intention that a rape would be committed.
Yes.
Yeah. Yeah.
But the court said that there was only one of them who wanted to commit the rape.
Right.
So the other one could not have the intention to commit the rape. He was acting only as an accomplice, but not as a courter.
Right.
Yeah. The case of Alexis, which is at page supplemental bundle 2, where the accused was prosecuted for manslaughter, was found guilty. And in this case, two of the grounds of appeal raised was that there was no evidence of common purpose, courtship, and also there was no intention on the part of the appellant to act as a courter. And
So which page is it, sorry?
page SB2.
Two.
Yes, 2. The relevant page in this judgment is page SB4, where in at the bottom of that page, the court referred to Archibald and said that the relevant principle obtained in France are in substance not much. It's not exactly similar, so not much different from what is obtained on the matter in England. And that was the extract quoted: when two or more persons embark on a joint enterprise, each is liable for the accident in persons of the joint enterprise, includes liability for unusual consequences. That includes liability for unusual consequences if they arise from the execution of the agreed joint enterprise. However, if a participant in the venture goes beyond what has been tacitly agreed as part of the common enterprise, the other participants are not liable for the consequences of that unauthorized act. And the interesting part is the directions that were given by the judge, which is reproduced at page 6 of the judgment, where the learned judge provided the requirements that need to be established by the prosecution. For accused to be a courter, it must be established by the prosecution that accused had embarked on a joint enterprise with the other assailants with a common purpose. Accused doesn't become a courter merely by participating in the crime. If his acts being extrinsic, then he is only preparing, facilitate. But the fourth paragraph of that extract is important, and I quote, "It is not necessary for the prosecution to prove any prior planning to commit the intentional killing of the victim. They may have decided to act in concert for such a purpose on the spur of the moment, as they help each other in pursuit of such a common objective. The common purpose may thus be formed on the spur of the moment, and nothing need to be said at all between them, as it can be inferred from their conduct." So this is where we say that there may not be direct evidence, but if there is sufficient circumstantial evidence, the court might infer no evidence that it was planned beforehand, but the acts, what they did, would be relevant for the jury to decide, to infer whether there was a common objective.
But the common purpose must be to kill.
Must be
That's what the
to kill.
judge says in the second paragraph.
Yeah, my lady.
Whereas there was no such direction here. The judge says they must have acted in furtherance of a common purpose, but not a common purpose to kill.
I reiterate what I said earlier, that is, it was not directly on that point, it was given generally, and I referred to the judge mentioning to the two assailants and so on and so forth, so that would be my submission sufficient. And also, in that case, at page 7, it was said that if someone is saying that he didn't act as a courter, he should have not join in this case, the assault, the physical harm. And in fact, he failed to dissociate himself. So in the present case as well, at no point in time did the appellant dissociate himself. He joined in, he tied the shirt, tied the mouth with the shirt, and in so doing, we submit he became a porter. And
if that's a convenient point, Mr. Director, that clock's not working. Oh, the lower one is. Might be a convenient point. I don't know how much longer you have in this.
I think I will take about half an hour at most, but I'm in the hands of the court if there's any specific issue your Lordship would wish me to address.
Yeah.
Well, we'll adjourn now and we'll resume tomorrow when we'll hear the completion of your submissions and we'll hear the report.
Thank you very much, my lady.
Thank you all very much indeed.